challenging a list which purportedly has been issued pursuant to orders of the Honorable Supreme Court, although it will be appearing from that particular order that it has been issued, concession made by the learned senior advocate. So therefore, my lord, my first contention would be that the language of the list, first covering letter, is erroneous. First kindly comes to the impugned list, 281, volume 2, and takes note of the numbers of the list. My contention is that this particular list does not include the persons who have been found to be tainted, but have included persons who have not found to be tainted. That is us. And the persons who have been found to be tainted are the persons who had been appointed after expiry of the panel, which has been severely criticized by the Honorable Supreme Court. Kindly seize first the list, 281. This is the list, impugned list before Lordship. May I just place the list? I'll come to the order of the Supreme Court later. In compliance with the order of the Honorable Supreme Court of India dated 28/8/2025 in the matter of such and such, the list of candidates as mentioned in list 1 is attached below, who were selected, whose selections has been set aside by the Honorable High Court and confirmed by the Honorable Supreme Court, is hereby published in the official website of the West Bengal's Central School Service Council in order to place the list of such tainted candidates in public domain. Now kindly comes to the last page of the list to see what are the numbers. My name is also there. 300, yes, 1804, 313.
So your name is there in this?
Yes, my name is there. That is the challenge. I am saying that this list is erroneous. 1804 are the numbers. Now, my lord, kindly comes to the Honorable Supreme Court judgment.
There is another list, next page.
Next page is the list which has been sent to the counseling centers of the same persons with indicating the numbers, so that if these persons come, please don't allow them to participate in the process. Now, my lord, kindly comes, this is the list that I have shown to your lordship, is the list containing the names. Now kindly comes straight away to the, well, first kindly comes to the affidavit of the commission filed in the first round of litigation, and thereafter I'll draw your lordship's kind attention to, my lord, the the Supreme Court order. Kindly comes to page 100 and page 48 onwards. First, may I just demonstrate before lordship who am I? 2 pages, page 39. This is to substantiate, this is petition number 2. This is to substantiate that I am an impaneled candidate. Kindly see there, result status impaneled, general.
Yes.
Next is the petition number 2. Kindly comes to page 41. This is to substantiate that I have not given blank OMR. This is the OMR sheet. Now she would see I have not submitted blank OMR because that is one of the categories. Page 41 and 42 are the OMR sheets. Thereafter, my first appointment, which has now been cancelled. Now kindly comes to the affidavit of the commission in the first round of litigation before the Honorable Division Bench. One remark, page 51. This is the affidavit which starts from page 48. This was before the Honorable Division Bench, presided over by the Honorable Justice Devanshu Bosak, which had cancelled the entire selection process. This is the affidavit. Page 51 are the statistics which has been given. Last, all identified rank jumping cases are post expiry of panel.
Where you are reading?
Page 51, remark portion. In the first, here.
Yes.
All identified rank jumping candidates are post expiry of the panel. Why I am showing this? Because to substantiate that they had not given a specific list of the persons who are in this post expiry of panel. Now kindly comes to page 139. This also formed the part of that particular affidavit. There, they had disclosed one list of candidates. Kindly see the top list of candidates called for 8th phase counseling dated 3/8/2020. Kindly takes note of this, the date and the 8th phase counseling, because I will be trying to substantiate before your lordship that by the order of the Honorable Supreme Court, the counselings after 1 year of the expiry of the panel are all bad, because that will
Go
be
and seek the clarification
Why?
from Supreme Court.
Supreme Court has said so. That clarification is already there.
Supreme Court orders are on record.
Yes, that is what I'm.
Now,
Yes.
Mr. Lahiri, don't make an argument which is totally different from what was argued in the various ranks of litigation.
No. This
What has
argument
the
this has been
learned
upheld.
What had the learned judge said? That this issue which you are agitating is a subject matter in a pending application before Supreme Court. So now, if
Another
your
point also that the Honorable Judge has said.
Please
I'll-
listen.
Yes.
if your argument is that this I am not covered by that,
Yes. And someone else who was covered
Someone
has not
else
been included.
which you are showing,
Yes.
this has to be argued before the Supreme Court.
If-
Supreme Court has said
Sure.
that no tainted candidate should be allowed. Now, this issue is pending. It is not a denial. That issue is pending.
My
Why
humble
you are
submission is
seeking
this.
repeated dismissal of your case?
Why I'm saying because
You should
the-
go to the Supreme Court and say that, my lord, we are not
Kindly-
in this.
yes.
Kindly interview list is over. You kindly reserve 2 vacancies for us and hear our matter.
Now,
Finish.
yes. I can do that. But before that, my lord, kindly, my lord, if I can
So,
convince your
Mr.
lordship.
Lahiri, you first satisfy us. Is this fact wrong that the issue is pending before Supreme Court?
No.
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 So you want participation on the examination which is scheduled on 7th.
Yes.
If we dismiss the appeal, you won't be able to participate. That is the urgency involved.
Yes.
Now, today, Mr. Lahiri, when the judge, upon noting your submission, says that there is no dispute about this fact that Supreme Court is in sitting, how can I pass the order?
No, I understand, but the Honorable Judge has also said that these persons who have been identified as tainted, and has been specifically said by the Honorable Division that these only 3 categories are tainted, are not conclusive.
So say that before the Supreme
There is a finding which I have to overcome. That is why I am before your lordship. Kindly allows me 10
Single
minutes.
judge is not superior to Supreme Court.
Yes,
So
but my lord,
whatever
kindly.
he has made, he
Yes.
has ultimately relegated, saying that I cannot be asked to pass any order at this stage.
But there are findings. That is why I am troubling your lordship. Otherwise, everyone knows by 7th I will not be able to go to Supreme Court. So therefore, I am before your lordship.
Everyone,
By 7th we will not be able to go to Supreme Court.
doesn't matter. If the interview
That is why I am before your lordship.
it doesn't matter. Did the Supreme Court say that irrespective of pendency, you allow everybody to appear?
No.
So when it has not been said,
No.
Mr. Lahiri, how we can impinge upon such observation?
My contention is that Supreme Court has also said that persons who are tainted should not sleep in.
Very good.
Yes.
That is your
I'm
strong
trying
ground.
to I'm trying to substantiate that.
No, don't substantiate before us. Go and substantiate before
I
Supreme
will.
Court.
If I cannot substantiate, if I fail before your lordship, I may. Well, ten minutes while your
What
lordship.
we are doing, we are listening to you. We are expressing tentatively our mind.
Yes. That is. I bow down to that. It helps us to, my lord, substantiate our case. If your
Lordship
lordship
case is on the basis of the 365 paragraph,
63,
66 or whatever it
Yes.
is, Supreme Court has denoted only 3 categories. No,
not Supreme Court, Division Bench,
whatever it is.
and upheld by the Supreme Court.
So I do not come.
Within that 3 categories.
Very good.
Yes.
When you do not come under the 3 category, who will give the verdict? Tell us. Is it not the Supreme Court? That Supreme Court, upon considering your argument, will give the verdict that yes, these teachers are not coming within those 3 criteria. Not coming within those, so they ought to have been allowed. Supreme Court has not injuncted against your admit cards were issued. Today you are in a
Admit
position
cards have been cancelled.
issued and cancelled.
Hmm.
Now, when the Supreme Court again took up the matter, the observation of the council appearing for commission was also recorded.
Yes.
That no, it is not restricted to 3 categories. So Supreme Court said, all right, we will consider.
That is my contention, that it has been restricted to 3 categories in a division bench judgment. Subsequent division bench judgment passed by the Honorable Justice Somen Sen, presiding over the bench, and that has not been taken into account by the Honorable Single Judge. That is what I am trying to substantiate before lordship.
Admitted.
Kindly,
Accepted your plea.
yes.
Now, who will adjudicate? Tell us.
My lord, if in my humble
adjudicate?
submission, this is a subsequent cause of action because there is a list. I have, my lord, remedy before the single judge division bench, then only before the Supreme
If you take a view that whatever the court says, don't listen to it, I will make my extensive submission
No.
and then let the judgment be
No.
delivered. If that is your stand,
That is not my stand.
then if it is not your stand,
My lord, we have been
points will be kept open. You go and say to the Supreme Court.
then, my lord, kindly, my lord, allows
No,
me.
it is a decision. You being the counsel, you may not convince your clients that why this query is being put to me. You understand the situation. But Mr. Lairi, kindly consider one thing. Repeated dismissal of cases will only it sends a bad signal.
Yes, but we cannot directly go. Single bench, we cannot go. Supreme Court doesn't entertain.
I am
If it
not saying that you file fresh SLP against the order of the single judge. Paragraph, kindly come to his lordship's order.
Yes. Last paragraph.
You know that very well. You are handling these matters for so long.
Paragraph 21,
Huh?
SLP such and such pending for further consideration such and such in connection was published containing names of tainted candidates. Therefore, this court finds that these are not fit cases where the court should interfere with the list dated such and such containing names of tainted candidates when the Supreme Court is in session of the matter. But my lord, with regard to the observations of the honorable judge, my lord, because the honorable trial court has not recorded my submission with regard to the division bench.
Doesn't matter. Even whatever observation made, it will be subject to the verdict of the Supreme Court. All your grievances, because today if the interview is whatever test is sent, okay, selection process has been directed to be concluded within December.
Yes.
So today, suppose you do not get the opportunity to participate, and the Supreme Court matter not ultimately, if the Supreme Court finds that your argument is proper, that yes, this person is saying the right thing, 3 categories earmark, he does not fall within that, why should he be included within the tainted group? We understand your submission.
There, my lord, by that time we have lost. If I can prima facie satisfy your lordship that the list is erroneous, persons who are not supposed to be in the list.
No, if you are not inclined to give any weightage to what we are saying,
my lord, I am totally inclined, my lord.
We are prima facie expressing our mind.
Yes.
For your benefit.
Yes, my lord, I understand, my lord.
Repeated dismissal on 5 stages sends a wrong signal, Mr. Lairi.
But
I cannot say that you withdraw the petition because
I cannot also, my lord.
You can say at least that yes, I will place these matters before Supreme Court as the learned single judges say.
My lord, that can be done in a different forum also, my lord. That is, my lord, I am not, my lord, there to, my lord, give advice with the other clients, my lord, for whom I am not appearing. My lord, only may I just try to substantiate before lordship that the list is wrong. Lordship may kindly, my lord, takes note of my submissions and says I will show mathematically that the list doesn't contain all the names. Pure plus minus, my lord. Kindly, my lord, takes, my lord, this, my lord, page 139. This is the 8th phase of counseling. These persons are also not there in the list. Kindly, my lord, doesn't take me amiss. I will not take more than 5 minutes.
No. We are ready to hear you.
Well, we have been
don't misinterpret the court.
Yes, well, we have been doing extensive hearings before your lordship. We have seen your lordship's patience.
It is not a question of patience. It is a question of putting a balm on your wounds. You are out. You cannot get back. Point sealed. So what maximum you can do to tell the Supreme Court that, my lord, we are subject to what you argue, that even if the examination is over, cut-off date is till December 31st. And the Supreme Court says that yes,
examination is over, everything is.
No, that will not be an embargo, that the test will be over. Test will be over cannot be an embargo, because if it is found that you are really not tainted, court will direct you hold the interview. You know that very well. If there is an apparent
first of all, my lord, we are facing this. First of all, my lord, we are good bit indifferent to the tainted list.
We have.
So we do not expect any equity from anywhere. We are trying to substantiate before lordship that the list is bad. That is all. If my lord is of the view, if I can substantiate prima facie that the list is bad, then my lord may direct that in view of the erroneous list published, which is starkly in conflict with the order of the Honorable Supreme Court, I may be given a chance to sit in the interview without any equity. And there is already orders. Even if I am appointed, I will not get the job. I know that. But this chance, as of today, balance of convenience and inconvenience is in my favor. That I will try to substantiate. That is why I am attacking the list, saying that the list is erroneous. There is some error on the part of the commission in publishing and the including of the names. Now, kindly see page 139 is the 8th phase counseling. Kindly takes note. Lordship has already taken note of the date, 3rd August 2020. This list is merely of 183 candidates who have not been included in the tainted list. There are lists. The expiry panel starts
When
from
was the list published by the commission?
expiry, the list of malod persons.
That was in August, no? 20.
Just the list of malod persons who are there in the expiry panel has never been published.
The
Final publication.
tainted list, which has
Oh,
been
tainted list is 30th August. Impugned list, 30th August.
30th August.
Yes,
So 30th August 2025.
2025.
This is the list by the commission filed.
Impugned in the writ petition and before your lordship.
This page 139 is pertaining to the initial selection process.
First selection process,
It's 2016 RLS.
2016.
Very
2016 SLST.
Very good.
Yes. Now, my lord, this is my contention is that these persons are also not there. Now, kindly comes to the Honorable Supreme Court direction.
Now, these persons were called for counseling.
8th phase of counseling.
Yes.
So
you
after-
were also called for counseling.
First, second phase.
Yes.
So we are the Honorable Supreme Court and the Honorable Division Bench has specifically directed that persons who are been appointed after expiry of the panel is illegal. But the commission, while publishing the tainted list, has not taken into account that. That is my contention.
When was the expiry of the panel?
Expiry of the panel was the date of publication of the panel was 12 March 2018. Expiry of the panel would be in accordance with Rule 21 within 1 year. That is 13th March 2018. So anything after 13 March 2018 is after expiry of panel. Now kindly straight away comes to the Honorable Supreme Court. No, first one page and thereafter I'll go. Page 158 is that paragraph 363.
So you were given appointment prior to 13th March 2018.
Yes. September 2018, January 2019.
No.
My appointment, January 2019, September 2018, March prior.
Your panel was valid till 2018 March.
Yes. 2019 March.
19 March also. So within the validity of the panel, you got the appointment.
Yes. So I am not expiry panel candidate. Page 158, I'll be just running through my first one. Page 158 is that page paragraph 363, which has been quoted in the Honorable Supreme Court judgment. Kindly seize paragraph 363, subparagraph 4. Lordship is there.
Yes.
Persons who have been appointed outside the panel. These are the persons who didn't even participate in the selection process but got appointment. After expiry of the panel, these are the persons after that period, and also those persons who submitted blank OMR. So these are the three categories. Kindly comes now to page 1. Yes, second volume, my lord. Mathematics. Page 177. The Honorable Supreme Court judgment has been, my lord, distributed in 2 volumes. Kindly takes up the second one.
This paragraph was affirmed.
Yes, I am coming to that.
Where?
Page 177 by the Honorable Supreme. Kindly takes up the next volume, my lord. The volume ends at page.
Yes, 177.
Yes. Paragraph 24. Impugned judgment refers to the following statistical report submitted by the West Bengal State WBSSC.
The impugned judgment. Yes.
Yes. Or paragraph 23 also, Lordship, if I can.
I may speak for that.
Yes.
Where is the confirmation of that?
I will. Only 1-2 figures kindly takes. OMR issue 808
Yes.
in 910 and 771 in 1112. Rank jump 185 in 910, 39 in 1112. So this figure, if adds up, comes to 1803. I have done the calculation. Now the panel, now the impugned list.
1803, taking into consideration all the 3 issues.
No,
2.
OMR issue, rank jumping.
Just OMR issue and rank jumping.
No, the
Kindly adds up. Yes, OMR issue, alleged irregularity, kindly sees 993.
What
Rank-
is this? What is this alleged irregularity?
These are the irregularities which have been which have been taken note of by the Honorable Supreme Court. Alleged irregularity is the OMR issue and rank jumping.
No, paragraph 23 adds to the list given by the division bench. There's a 4th ground introduced
Yes,
in paragraph 23. which
Yes.
is rank jumping.
Rank jumping, all rank jumping candidates, that is why I've shown your lordship.
3, 4 did not have rank jumping. So
Yes,
this is an additional.
all rank jumping candidates are within the expiry panel candidates. That is why I've drawn your lordship's kind attention to the affidavit filed by the SSC.
No.
First affidavit that I've drawn your lordship's kind attention that all rank jumping.
Let us understand. Page 158, you said, paragraph Roman 4, division bench direction was
Yes,
page 1.
rank jumping doesn't use. Yes, yes,
Page 158 is a part of the Supreme Court judgment.
yes, 150.
Very good.
Where the
So
division
there
bench
were
was.
two categories.
See.
Outside panel.
After expiry of panel,
Oh, acha, acha, acha.
this includes rank jumping. From where will I find? From their affidavit. Here. All identified rank jumping candidates are post expiry candidates.
This rank jumping, where you find?
Yes, here. Page 51, I have drawn your lordship's kind attention to their affidavit. Here. All identified rank jumping cases are post expiry of panel. So post expiry panel includes rank jumping. So that is why there is no specific list. Post expiry panel is huge. That includes this rank jumping. That is 185 and 39. Now, I'll kindly cease. May I just do the mathematics first and thereafter show to your lordship where they have erred. So,
You are at page 177.
yes, 177. OMR issue 808.
How much does it come to? Total
It comes to 1803.
only 808 and 771. Others are relating to
808, 771, 185, 39. 808, 185 is 993. 771, 39 is 810, which adds up to 1803.
means for 9, 10 and
11, 12. We are only in 19, 11, 12. Group C, Group D. We are not there because there is no selection process initiated in respect of Group C, Group D.
No, you participated in which
9,
one?
10, 9, 10.
These two petitioners.
Yes, 9, 10. But the list is of 11, 12 and 9, 10. Combined list. That is why the entire.
Combined, but what is you have taken into consideration 808, 771, 185 and 39.
Yes.
This total comes to how much?
1803.
1803.
The list is of 1804. One candidate. So therefore, apparently the list doesn't contain the candidates who have been appointed post expiry of panel. Now, Mala kindly comes to the findings. Paragraph 30 onwards, page 181.
No. Why did you say it does not include
Post expiry panel? Because it doesn't say so here. OMR issue is included, rank jumping is included.
and what is alleged irregularity? Next column.
These are 808 plus 185 is 993.
I see.
171 plus 39 is 810. And if this 993 and 810 is added up, 1803.
But this rank jumping portion is post expiry.
Yes, but it is not all post expiry. Some of the rank jumping candidates are included in the post expiry panel, but all the post expiry panel persons are not there. That is my contention. Now, kindly comes to. Okay.
Wait, just give us more. Out of panel, second data, a third.
His commission has been candid enough to admit
No, post expiry. That is what I'm trying to show. Supreme Court has also said so.
No, that 139 which you showed us,
Yes.
the date is 8th of,
8th of August 2020.
August 2020.
8th phase counseling
very good. Counseling will be called
within
of which candidates? No.
of the impaneled and waitlisting candidates.
Right.
Yes.
So those who have already been included within waitlisted category, can their appointment be challenged on the ground that they are post expiry
They have been challenged. Supreme Court has upheld the challenge saying that that was illegal. Paragraph
which was illegal.
post expiry panel, paragraph 30 and 31.
Then why were you silent when the Supreme Court had said that all right, we were not, they will give further list, which has been quoted by Justice Bhattacharjee?
They have
no, it
they
is
were
not-
supposed to give tented list. How
No.
do I know that they will not include them
But
until
it's
the
not-
list comes out?
Come to that observation of the court, where the counsel submission has been recorded.
Yes, it has been recorded that the learned senior counsel has submitted that he will come up with the tented list.
Hmm.
Until the list comes out, we don't know who would be included in the tented list. So
Why
for the
didn't you
first
tell
time-
the court
For the first time, because it is already
that
there.
the interview will be over?
Because I am not a party there. In the Supreme Court, the matters where these orders are being passed, I am not a party. All orders passed behind our back. Now this has become a rule. We have, my lord,
Be
accepted.
careful making submissions. Be careful.
No, in respect of our matters, all orders from first day, my lord, from 2022.
Yes. Next point.
Now page 181.
Only one thing I clarify, it's not that. Supreme Court has very clearly said tainted candidate